Good morning, everybody. Happy Monday. Welcome to the Courtroom Files Live. We will start our day in Michigan with Judge Anzalone, where she's getting people to explain why they're deadbeats and can't pay their child support.
Let's see. So, sir, this is a first show cause, and failure to pay child support is a crime. And the maximum penalty, if you're found guilty or plead guilty to it, could be up to 45 days in jail. Do you understand that?
Yes, ma'am.
Okay. And Mr. Fry, how did you wish to proceed today on this?
Yes, Your Honor. My understanding is that I don't really know what this is. It shouldn't be child support. My client has the kids 100% of the time. It might be spousal support. We did have a friend of the court hearing, but we never received an order following it. So I'm not sure if one ever got entered and we just didn't get it, or we're still waiting on it. But as far as we're aware, there hasn't been a spousal support order entered yet. So, I mean, this is quite the surprise to my client. I'm not sure what's going on with this one.
Mr. Anderson, is this supposed to be spousal support?
I can answer that question. He's muted, actually.
Yep.
I know.
Yeah, it is. Okay, go ahead.
So, okay, so it's supposed to be spousal support. Then, Mr. Sala, do you have an order?
We do. We actually have an order that was issued back to the date of filing. And there was an intake, there was a recommendation, it was objected to, it was sent back to the friend of the court. We had a hearing on February 10th in front of referee Grace Garno. She indicated that the original order remains in effect. So as of the date of filing, he's paid no spousal support. The order is in effect. I've been in contact with the friend of the court for about a year, trying to find out why it's not being garnished from his wages. The friend of the court has, Shawnee has tried several times to figure out why this is not being garnished. It's $13,052 as of 8/1 of 2024. My calculations are that's about $24,336 from the date of filing. So it's a little more than what Mr. Anderson has. I have both orders here. The court has them in the file. Mr. Anderson, I'm sure, is familiar with both of those orders. That's why he show caused them. So we're trying to figure out basically why his employer, who his employer is, and why they're not garnishing for the spousal support. The order is in effect. They sent out withholding orders, and we believe his employer is either ignoring it or they're sending it to the wrong employer. But in any event, that's where I'm at, and I'm sure Mr. Anderson can substantiate some or all of what I've said.
Thank you, Mr. Sala. So, Mr. Fry, do you have anything to add?
I mean, if it sounds like there is some type of order, we never got that. We would have objected if we would have gotten that referee recommendation, it sounds like. So I'm not sure what's going on there. I mean, happens time to time, I guess, where for some reason the front of the court it gets lost in the mail or they don't send it. I don't know. But my client's worked at the same place since this case has started. So if there was an order, it's unclear why there wouldn't be garnishment going on.
Okay, so here's what I'm going to do. Mr. Fry and Mr. Salam has set this over to July 14. Mr. Fry, obviously you need to advise your client that these payments need to be made automatic by himself if they're not being withheld, but he should pay directly to MISDU. And that'll give you an opportunity, Mr. Fry, to get a hold of the order and look through this with your client. I'll enter a plea of not guilty on his behalf, and we'll see you back on July 14 at 8 a.m.
I would only ask, Your Honor, that he confirm where he's working for Mr. Anderson. So we know where to send the garnishment. Make sure we're sending it to the right spot, because obviously we may have to show cause his employer.
Mr. Anderson, is there a garnishment?
There is, but yeah, I would like to just confirm where the employer is.
Where do you work?
I am employed with Cabinet Works Group,
Cabinet Works Group.
and the address is 20,000 Victor Parkway.
What city?
Livonia.
What city?
Livonia.
20,000 Victor Parkway, Livonia, Michigan. All right, so Mr. Anderson will look into that.
Thank you.
And we'll see you back on July 14th. Thank you.
Thank you.
Thank you. You're all set. All right, I just admitted somebody on an iPhone. Could I ask your name, please? Okay. In the matter of Dorinda Williams versus Timothy Williams, that matter has been adjourned to July 14 at 8 a.m. That's file number 1990-12245DM. In the matter of Rachel Donald versus Joshua Donald, file number 2013-39592DM, that's been adjourned to October 16. In the matter of Kendra Six versus Kent Schroeder, file number 2018-45507. Hi, what is your name, please?
My name is Joshua Donald.
Okay, Mr. Donald, your hearing's been adjourned to October 16th, so you must be making payments, so thank you.
Can I ask you a question real fast, ma'am?
Sure.
Is there any way I could get my license reinstated?
Does anybody know if this is in the matter of Rachel Donald versus Joshua Donald. I don't know who, let me see, who's your caseworker? Looks like it's Kelly Cam, but can anyone, I don't know that, anybody know if we suspended his license?
She would have to look into that, Your Honor. There's a couple of steps that would have to happen before that can take place, but he can contact her and then she can look into it.
So, Mr. Donald, your caseworker is not on today. She's, they rotate who's present. So,
Okay.
Mr. Donald, I would say call your caseworker and talk to her about it.
Okay, thank you.
You're making payments, you're doing what you're supposed to do, so, that bodes well for you. Thank you.
What's the date again?
October 16 at 8 o'clock.
Okay, thank you.
Thank you.
Yep.
All right, I don't know if I said it, but Kendra Six versus Kent Schroeder, file number 2018-45507 DC has been adjourned to July 14. Veronica Hemsoth versus David Hemsoth, file number 22-49758 DM has been dismissed. And let's go back. All right, so Mr. Holt, you want to come on up? All right, this is in the matter of Sarah Holtz versus Timothy Holtz, file number 2008-33341 DM. Mr. Holtz, we are here today on a continued show cause. I don't know, did we appoint counsel for you before? I don't think so. So, Mr. Holtz, you have an order of $778 a month. You have an arrearage today of $4,689.50. You did postpone and pay $2,500 on May 28th, which is the only payment ever made on this case. We have still not, does anybody know if we did receive Mr. Bender did verify he had overnighted it 5 days ago and we never received it yet. Do we know if we received that check yet?
Not, Your Honor.
All right, so your counsel, Mr. Bender, did verify that he had overnighted a check to my staff, and that was about a week ago. We haven't yet received it. I'm going to set this over. Miss Adams, when's my next Monday? July 14? Okay, I'm gonna set this over to July 14 at 8 a.m. to verify making that we received it, and then you are self-employed, so you need to make your payment in person. So if it's $778, you need to divide that up and make weekly payments or once monthly one, all right? So we'll see you back on July 14th to verify that payment.
Okay.
Thank you.
Thank you.
Good morning once again, everybody. Welcome to the Courtroom Files Live. So I want to let you know, hang around till the end of the show. I've got something special to announce, something new that we're doing, and if you like courtrooms, which I'm guessing you do since you're here, this will be of great interest to you. So hang around until the end, because at the end of the show we will be launching and announcing something I think is pretty cool. So hang tight for that. In the meantime,
Dollars
there we go. Wrong button. In the meantime, let's go to Texas and Judge West.
Well, when you were here last time, I told you you had to work on trying to hire your own lawyer and you needed to actually speak with 3 lawyers. So where's this Mitchell Woods?
I didn't speak to him. Just spoke to the one, but I was supposed to bring 3 attorneys up here for you.
No, it's not just, I'm gonna write down 3 names. I said, go talk to 3 attorneys, at least 3 attorneys, and try to hire them. It's not just, I'm gonna give you 30 days and you come back and you write down some names, because Mitchell Woods is probably Clint Mitchell Woods, who is a judge down the hall. So you didn't talk to him as a lawyer. Brack Jones has been retired for many, many years, doesn't practice law. So you didn't do what I asked you to do. Hang on. You didn't do what I asked you to do. And so the result of that is I could put you in jail for not following the court order. It's not just a game to go say, I did what you told me to, because you didn't. I'm gonna reset your case for 30 days. You need to try to hire a lawyer. If you don't hire one, you better start calling this week actual lawyers that practice law and make appointments and visit with them. All right, because I've been here a long time. I know who the lawyers are around here, so you're not going to get one over me by just writing down some names. Step in front of the clerk and get the reset notice. Sammy Morris. Of all names. Good morning, sir. What made you think that was a good shirt to wear to court this morning? That's all you could find? That's all, the only shirt you had in your closet? World's best farter. That's great. No, it says, I can read it. I see what it says at the bottom. You're in felony court. You need to dress appropriately to felony court, and that's not appropriate. Did you get someone hired? I can't hear you. Okay. Okay, who else did you talk to? I can't hear you. Okay. All right, so why didn't you call some others if they didn't call you back? None of them, I don't believe that for a second. None of them answered their phone? Okay. How many others did you call? I can't hear you. That's it. So you called 2 that didn't answer their phone, 1 that didn't call you back, and you didn't think to keep calling and talk to at least 3. You didn't try if you only did that. This isn't that hard. The point isn't, just like you just heard me tell the other guy, the point isn't to play a game and act like you call and write 3 names down. The point is to actually hire someone. And you can't actually hire someone unless you really try. I'm going to reset your case for 30 days. You need to get someone hired, or you need to actually talk to 3 lawyers. And if you have to call 20 to get that done, then call 20. Start this week. Don't wait till the week before court, because they are in court. These are just normal common sense things, right? All right, step in front of the clerk. If you don't do that, the next time your bond will be revoked and you'll go back to jail. I feel like I need to start over. I didn't start no. Naquinda Niclese. Good morning. Did you get somebody hired, Mr. Niclese?
I was supposed to get right, you said from last week.
Right.
I got to keep getting it on my plateau, and I had to go to the ticket court and pay them, so this is a question, and I would have to get a question. I have 150, he want 300, I have 150 on it.
There's a, There's a drug screen in his file that doesn't belong in his file. All right, I'm gonna have you fill out some paperwork this morning. I know you've been trying, and see, I'll take a look at it after you fill it out. It's important that you fill it out accurately and completely. You're gonna swear under oath that it's all true and correct, so make sure, don't just leave it all blank. Put everything in there. The clerk will give you those instructions and tell you what to do. Yes, sir. Diamond James. Good morning. Are you Diamond James? And Miss James, this is your initial appearance in cause number 25 DCCR 0437. Just a second. You're charged with a third-degree felony offense of hindering apprehension or prosecution of a known felon from March 5th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? No. So what I'm going to do, Ms. James, is reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They all have different payment plans. If you're sitting in here, you've heard it's not just a game to come in and tell me that you've write 3 numbers down. You need to actually speak with at least 3. The point of this is to try to hire a lawyer, okay? But bring me back the names of those that you've contacted and talked to so that I know you're trying, and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond and you would have to go back to jail. Do you understand? As a condition of your bond, were you ordered not to have any contact with Jacqueline Young? You were? Okay, I want to make sure you understand how important that is. You cannot have any contact or communication with him. That obviously means in person, but it also means through social media and DMs and whatever else is out there. If I find out that you've had any contact or communication with him, then your bond would be raised and you go back to jail. You understand? All right, step in front of the clerk. She'll give you your reset notice. Brashana Weston. Good morning. Are you Brashana Weston? And Ms. Weston, this is your initial appearance in cause number 24 DCCR 2448. You're charged with a second-degree felony offense of burglary of a habitation from June 17th of 2020. Goodness gracious. So since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Okay. How old are you?
21.
Okay. So this is something that they're saying happened back in when you were,
As a minor.
how old were you? 18 or 17?
No, I was way younger than that. I was like 15, 16.
June of 2020. If you were born in 2024. 2004. Mr. Nichols?
Yes, sir.
I just want to double check the dates and her age on this.
Okay, what's her name?
It's Brashana Weston, Weston.
How you spell Brashana?
Brashawna. Were you certified as an adult? Huh? Oh, okay. Just give me a second. I'm going to look at some. So if you were born, look, you're going to make me do math. Hold on. When's your birthday?
March 6th, 2004.
So you might have just turned 17 before this, because this is from June. So you would have been 17, which means you would have been an adult for purposes of court. All right, so never mind. Sorry, Mr. Nichols, just took me a minute to do some math. So Ms. Weston, have you had an opportunity to try to hire a lawyer? All right, so what I'm going to do is reset your case for about 30 days or so to give you some time to try to hire someone. If you get a lawyer hired before the next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They all have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. You heard me. You heard what's going on this morning. This isn't just I'm going to write down 3 names and act like I talked to them. You need to talk to them so that you can tell me what they said so that I know you're really trying, okay? Don't wait till it gets close to the court date because you need some time to make appointments to visit with them. So get started on that this week. If you don't do all that, then when you come back, you run the risk of me raising your bond and you would go back to jail. Do you understand? All right, step in front of the clerk. She'll give you your reset notice. Lamira Henry. Lamira Henry. That's weird on the burglary for them to indict so many years after. Good morning. How are you?
Thank you.
That door's locked. Y'all have to go out the other side.
Good morning.
Good morning, ma'am. You're Lamira Henry?
Yes, ma'am.
And Miss Henry, did you get someone hired?
I talked to a couple of lawyers.
Okay.
They get hired.
Who'd you talk to?
I talked to Parker, a guy named Parker, Alan Parker.
Mm-hmm.
I talked to Kevin. I talked to James Macon
Mm-hmm.
and Kevin. I know his name, Kevin. The number is 498332872.
I don't know everybody's number.
But that's the 3 guys that I talked
Okay.
to. I'm out with the job I work. I make like $1,600 a month. They
Okay.
want like $7,500,
Right.
$500.
So I thank you for doing what I asked you to do. I'm going to have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer.
Okay.
You need to fill it out accurately and completely because you're going to swear under oath that it's all true. So put what your bills are, put what your income is, and then I'll take a look at it, okay?
Okay.
If you step in front of the clerk, she'll give you that information
Thank
and
you.
instructions. Yes, ma'am. Eric Fornolls.
So while we wait for this next contestant to come up, I want to show you something real quick. This is Judge Allen in Ingham County, Michigan. And I'm not going to go to him because I'm not overly excited about the hearing he's doing at the moment. But if you look in the top left, he's got a ring light. So kudos for him for trying to do good production value, I suppose. But I've never seen that ever in front of a judge. I've never seen somebody on the bench have an actual ring light to light their face. So I just found that interesting. Anyways, let's go back to Judge West.
Actually, his price was cheaper at $4,500. Then the last one that I talked to was Ben from Gertz and Kelly. That was on 5/22, and they want $7,500. I'm still waiting to hear back from Franklin, James Macon, and Crenshaw.
Okay.
I did talk with all these, and we did go to the phone consultation. I told you before, I live in Lufkin, so it's hard for me to do so, but I
Okay.
did reach out. and
Thank you
ask
for
them to do that.
I appreciate that and the information that you brought back. And so do you think if I give you one more reset, you'll be able to talk to some others and try to get someone, you're working, right?
I am working. I'm working at a convenience store right now. I'm usually doing industrial stuff, but right now with the pending charge that I have going, a lot of places are saying, no, we don't not until you get something done about that. So unfortunately, I'm working at a convenience store, but I am working.
Well, no, I appreciate that you're doing that. I'll have you fill out some paperwork this morning, Mr. Fornos, to see if you qualify for a court-appointed lawyer. You just fill it out accurately and completely. I'll take a look at it, and you're gonna swear under oath that it's all true, so don't just leave things blank. Make sure you fill it out completely. Step in front of the clerk. Luis Rivas. Luis Rivas. This bond will be forfeited for non-appearance and reset at 100,000. Anthony Whitmire. Good morning, sir. You're Anthony Whitmire?
Yes, ma'am.
And Mr. Whitmire, were you able to get someone hired?
No, ma'am. I did talk to 4 of them, but there's no way I can afford their retainer fees. I'm not working right now.
Who'd you talk to?
Greenshaw, Walker, Willard Hall, and Gertz.
Why aren't you working?
My truck's down right now.
Okay. All right, so I'm going to have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Make sure you fill it out accurately and completely. You're going to swear under oath that it's all true and correct, and then I'll take a look at it. If you step in front of the clerk, she'll give you that paperwork and your instructions.
Yes, ma'am.
Anthony Williams. Good morning, sir. You're Anthony Williams. Mr. Williams, did you get someone hired?
I talked to 3 of them. I talked to James Meek, and I talked to Wilford and Walker.
Okay.
2 high.
All right. Did you, are you working?
Yes, ma'am, but I gotta check stuff. I got one I'm playing. So one of them is when I'm playing, it's active, and one of them is when I'm not playing. Like, really.
Right. So when do you play and when do you not, or how does that work?
So I missed what it was, like 2 weeks ago I missed, for my dad's funeral. But other than that, I've been playing.
Okay. I'm sorry about your dad. And that's each week?
Yes, ma'am.
That's all you make a week? You might need to get a different job.
I'm just chasing the dream.
Yep.
Chasing the dream.
All right, I'm gonna have you fill out some paperwork to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely. You're gonna swear under oath that it's all true and correct. So make sure you put what your bills are, what your income is, and then we'll figure it out. All right, step in front of the clerk, she'll give you that information. Kennedy Webb. Good morning. You're Kennedy Webb? And Ms. Webb, this is your initial appearance and cause number 25 DCCR 0258. You're charged with a state jail felony offense of either it's false alarm or reporting of an emergency from November 12th of 2024. And since you have made bond in your case, have you had an opportunity to try to hire a lawyer?
I have, but I can't afford it.
Are you working?
Yes, I recently just got a part-time job, and I'm also a full-time student still.
You are still, they didn't do anything with regard to that as far as, are you still a student at Lamar?
No, I'm at a community college back in my hometown,
Okay, and where's that?
Arlington, Texas,
Okay, what community college is it?
Tarrant County.
Okay, so I'm gonna have you fill out some paperwork this morning, Ms. Webb, to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely. Any income you might have, any bills that you have, put it all on there because you're gonna swear under oath that it's all true and correct, and then I'll take a look at it. Step in front of the clerk and she'll give you that information. Yes, ma'am.
All right, let's stay in the same building, but switch courtrooms, and we'll say good morning to Judge Stevens.
So what do you want to do? Just one reset and all right, to the next
Barrett
one.
Bishop. Barrett Bishop, Dustin Galmore. Okay. Ms. Stop, are we ready on that to go? Why does it say stop on?
Because it was hers, so I took it over for a certain reason, but I think that's going to be a plea according to Mr. Galmore, if I remember correctly. It should be please one, please.
Donald Barnes.
Just Mr. Lewis and I are working on a resolution. If not, I'm ready.
What does that mean, working on? I know working, I'm sure.
The offer that he's told me should be accepted.
Where is he? Is he
I
away?
haven't heard from him, Judge.
All these people in custody? No, Donald Barnes is not. Donald Barnes, could, Tommy, I ask you to call into the hall for Donald Barnes, please.
I think I saw his people house.
Have y'all seen Marvin Lewis at all today yet?
No, sir.
Okay, yeah, let's wait on him to get here, okay? Just let him go back outside. Let me know when he gets here, because he should have been here 10 minutes ago, and he's kind of holding up the train. Ricky Herring is now next call. You can't make this stuff up. Can't really do much without.
Mr. Kimler called in. I think he said he was ready on all his cases. And we're tracking down one witness, but I should be ready once we track him down before. He just doesn't live in a permanent home, so. I'll be ready this afternoon, thanks.
On Herring?
Yes, sir.
And I've got Jasmine Hall.
Steve is ready, Your Honor. You're good.
Okay, how long do you think that would take?
Not very long. I would imagine 1 day.
Okay. Is a defendant eligible for probation?
No.
Okay. Let's see. Do you know where your attorney is? He should be here helping you.
Yeah, I thought this was Friday.
He'd get in here whenever he ambles in on his own time frame.
Mr. Kimber did contact me and said
Yeah.
he'll be in another court this morning.
Which one? What's more important than somebody who could go to prison?
I
I don't know.
remember which one.
I don't know.
He did say he would be here this afternoon.
Always,
Be on both of his cases.
yeah, it always surprises me that some things are more important than what goes on here, but most of the stuff in here is quite important to the people involved. Oh, let's see. Yeah.
All right, well, it looks like he's still getting his day booted up, and I imagine his cranky level may go up a little bit as we go along, too. So we'll check back, but let's go back to Judge West for now.
To go. It's Mr. Burbank, Shaw, Doyle. Is Mr. Floyd here, Charles Floyd? On John Van Wright, 2 cases. Good morning.
Good morning.
Good morning, sir. You're John Van Wright? And Mr. Van Ryn is charged in each of his cases with injury to a child, elderly, or disabled individual. And what is the announcement?
Your Honor, Brennan Mitchell filed an appearance this morning. He's going to serve as lead counsel in this case, and I'm going to take a step back
Okay,
as co-counsel.
okay. It's obviously if he just filed it, it takes time to get through e-file, so we don't see all of that yet. Any issues, Mr. Smith? So one of these is an MTRP and one of them is a new case.
That's right, Your Honor.
All right. No issues with regard to any contact or anything that we're not wanting?
No, this
or-
wasn't somebody that knew this circumstance, but he only knew the victim. I don't anticipate that.
And probation's here, as far as, for now, everything's going okay? Okay, I'll reset the case, and Mr. Mitchell can get the information that you have, obviously, with regard to discovery. If there's anything else that needs to be turned over, we'll get an announcement at the next court date.
Thank you, Judge.
All right, thanks. Yeah, if you'll make sure and get that request in. Thank you. You're free to go. Mr. Pageant, you've got a Kelly McBride. Good morning. Morning. Good morning, ma'am. Are you Kelly McBride? And Ms. McBride, Mr. Paget has filed a motion to withdraw as your attorney. Do you have any issue with me allowing him to withdraw? I'm sorry? What?
I don't have a problem with him withdrawing.
Okay, thank
Not
you.
at all.
Okay, thank you. I'm sorry. And so I will grant that motion and allow Mr. Pageant to withdraw as an attorney. Have you started looking for another attorney yet? Okay, so what I'll do, Ms. McBride, is reset your case about 30 days to give you some time to get Mr. Samuel or someone else hired. If you get someone else hired before the next court date, I'm going to have you sign a reset notice today that tells you when you need to be back. Make sure you bring that to that lawyer and they'll tell you what to do. If you're unable for some reason to hire Mr. Samuel or someone else, and that's not going to work out, then I'm ordering you to visit with at least 3 other lawyers. As you know, they all charge different amounts, have different payment plans. Bring me back the information and the names of who you've talked to, and we'll discuss your options, okay? If you'll step in front of the clerk right here, she'll give you your reset.
Thank you, Your Honor.
Thank
May I be
you.
excused?
Yes.
Thank you.
Did you have that order printed, or you want me to print it? I got it. I'm printing it.
Oh, I'm sorry. Yes, it's a different shape.
Oh, that was gonna do, okay. Okay.
And the defendant's not gonna be.
Let's see.
Let's continue our tour of Jefferson County. We'll go to Court at Law 2, Judge Holmes.
It's Alejandro Hernandez. Mr. Hernandez, is that your full name?
Yes, sir.
How are you doing, Mr. Hernandez?
Great. What about yourself?
I'm doing fine. Thanks for asking, Mr. Hernandez. You're represented by your attorney Mike Jamal. Attorney Jamal, how are you doing?
Thank you.
And the state is represented in this case by Attorney Haley Simmons. Attorney Simmons, how are you doing?
I'm great, Judge. How are you?
I'm doing fine. Thanks for asking, Mr. Jamal. What's your announcement in Mr. Hernandez's case?
We've agreed to put this on the trial docket.
Okay.
I want to remind the court and the state and I continue to talk, but I have two motions that if the court wants to overrule them or deny them, but I have a motion to quash and a motion for specific disclosures. Both of them address the issues in this case, pretty important issues, I think.
Okay, we'll have to set that for a hearing.
Okay, but
Okay.
we'll work it out. And she can advise you, but
Okay, that's fine. Give us a reset date. Trial. Okay, this case will be reset for trial July 28, 2025. Mr. Hernandez, you're gonna get your reset from our coordinator. Once you get your reset, you're free to go. Mr. Jamal, you'll get your reset from the coordinator. Once you get your reset, you're free to go as well. Mr. Jamal, you have a blessed day. Mr. Hernandez, you have a blessed day.
Thank you, thank you.
Okay, you are.
Thank you.
I'll see you Friday.
Okay, I'll see you. Thank you. Thank you, Judge.
Okay, you are.
All right, he's muted himself. Let's go back to Judge Stevens. Looks like we got some business going on there now.
Talking about you. You needed to get our attention. I mean, we were about to send another warrant out. Well, that would have been a waste with you sitting 25 feet away.
We're ready.
You ready?
I'm not. I didn't even know he was here.
Nothing. We
Just
can't.
also it's just out without a bond, so.
Yeah, I mean, we got to fix this bond thing first. I mean, before we do anything.
Yeah, have a seat right over in there, sir. Have a seat right over in the jury box. Thank you. How does something like that happen? Dylan Smith? Is Dylan Smith here? That's you? Okay. Troy, just have a seat. Thank you. Troy Howard, Mr. Wilkerson again.
I'll hang around.
Ms. Dobb, are you ready on these?
That's gonna be the same issue that we had with Brandon Miller, Your Honor.
Johnny Davis Jr. Mr. Laird.
Right, assistant.
Yeah, that's yours, Mr. Laird.
What's mine?
I think Davis too.
You can do that.
We're way down the docket now.
Is it? Yeah, but
I don't even remember which one this is because I've been looking at something else for money. Oh, yeah. No, we're dismissing it.
Okay, that's what I thought.
what are you gonna do?
I think it's gonna be dismissed.
This is gonna be disposed of without a trial?
Yeah.
Okay, get that.
I did look at it again this week.
All right. All right. Let's talk about this one with about 5 different lawyers on this thing. Henry Green.
Langston has all of those cases except for one. Or.
Gonna do anything?
Ready? I was doing last.
17 cases.
He is. Oh, he's incorrigible. I mean, Mr. Sonny gave a great deal to move all of them. I don't know what's going on. He's kind of belligerent and combative, and he's been in here before. I moved few cases off the trial that. Hey, this one was different.
The one with 17 would be
Yeah.
real interesting to do though.
Yeah,
I think.
he's
Yeah.
he's a worker. But I mean, you talk to him, you'll see.
Hey, do you want to have the files over there?
Oh, sorry, yes, they were just a big stack.
I think most of these are one case.
One case dismiss everything. He's, so. I don't know. But we show that. Is it young?
I see probably the latter issues. So like the jail assaults can be enhanced because the sex offender case want to enhance them, but the sex offender case is jurisdictional, it's outside of the sex offenses, I found. Yeah. That's been fixed, so it's had to do.
You want to try and talk to him again this morning?
Hey, I do not have a problem doing that.
I mean, it's just one, like I said, I both agree. We should be able to move it. He was incompetent, then he's competent, but he's still.
Belligerent.
Yes. 100% plus 100%.
Let me know.
I'll go back and give another.
I mean, I've essentially made an offer on one single case to dispose of everything.
Yes, and I was with him last night.
And did he comprehend how that how did he comprehend
Like I
what you were
said,
talking to him about?
When we get a chance, I don't want you to talk to teach.
Yeah.
You form your own opinion.
I'll take him home and, watch him and see how things are over the weekend. Yeah.
And I think you only need a few minutes to get a better assessment. If I remember how he has behaved in the court in the past. So if we have to, I'm ready on the sex offender case. For him.
But I'll give it another go to this morning.
But it's just one that should plead.
Give it the old Boy Scout try. Okay. Marvin, on yours, what are you going to do on Donald Ball?
Well, Judge Stevens is entertaining to watch for no other reason than his facial expressions. Bodie, good morning. Good to see you. Let's go to San Antonio. We'll continue our tour of Texas, which for some reason is happening today. Let's see Judge Boyd.
To Monreal? No, but she isn't. No, you need to.
I got excited. I saw you.
Oh, no, hi. Oh, yeah, all right, so let me explain something to you. I understand that you're his parents, and he seems very young to me. But once they're charged with a felony offense, they're considered legally to be an adult, right? So you're not allowed to come up here with him unless you're coming as witnesses, okay? But you can come to court and everything, but he's here with his attorneys, all right? And what I can tell you is this, because I know parents are concerned. We want to be involved, right? And we want to know everything that's happening. But this is what I'm going to tell you. I've been a defense attorney before, and I'm sure they'll tell you. If you are in on their meetings with him where they're discussing things, it's no longer confidential. That means that the state can call you as a witness to figure out, if they want to, what happened, what was said. So even though you're his parents, he's an adult, they're his attorneys. What I can tell you about these two attorneys, nothing's going to happen unless y'all know about it. Nobody's going to, yes.
Those are the victim's parents.
That's the victim's parents.
Oh.
His mom is in the courtroom.
Ah, hey, Mom.
There's the victim's parents.
Okay, they said they were the parents. All right.
No, I'm not his parent.
Okay, so you all need to step back. Whoa. Hi, Mom. Everything's gonna be fine. All right. All right, so you want an appointment of a second chair,
Yes, sir.
and that will be granted. And I'm assuming are you retained or no?
Well, as part of the bond situation, yes, as part of the bond conditions, I am retained.
All right, so what I'm gonna need to do, if you want the court to appoint a second chair, I need to get some information about his finances.
I can tell you, it was a paper to make the bond, and I can tell you that he is.
Oh, well, I need to call him to see. All right. Court is calling 2025 CR 00605 State versus Roberto Monreal. Can I have parties announce?
Nick Aguilar on behalf of Roberto Monreal.
And I'm sorry, this is just for an appointment of a second chair, State. All right, and are you Mr. Monreal?
Yes, Your Honor.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Roberto Monreal.
All right, so defense, you're asking for the appointment of a second chair?
Yes, Your Honor.
All right, if you want to ask your client questions about financial?
Absolutely, Judge. You already stated your name, please.
Yes, sir.
And how old are you?
I'm 18 years old.
And how long have you been 18?
A month, like short of a month.
Okay. And are you currently working?
No, sir.
Okay, and before you bonded out, how long were you in jail?
About 3 months.
And before those 3 months, were you working?
No, no, sir.
So you have no assets at all in your name?
No, sir.
Okay, and where are you living?
With my mom.
Okay, and your dad lives in
Phoenix.
Phoenix, Arizona?
Yes, sir.
Okay. I know it was a group effort to make the bond, right?
Yes, sir.
Between your mom and dad,
Yes, sir.
and they're separated, divorced?
Yes, sir.
Okay. Do you have the funds to hire a second attorney on the capital murder?
No, sir.
Okay. Have you looked into it or your parents looked into it?
Hiring a second attorney?
Yes.
Yes, sir.
Okay, Roberto, are you currently going to school?
No, sir.
Okay. Have you graduated from high school?
No, sir.
And how short are you from graduating?
3 credits away, sir.
Okay. And you're currently on GPS monitor?
Yes, sir.
Okay. And how are you paying the monitor fee?
My mom is, sir.
Okay, so you can't even afford a $300 monitor fee
No,
yourself?
sir.
All right. I'm gonna grant the motion. I'll appoint a second chair and then state who's going to be handling this case. All right, Mr. Garehan, on this case, are you all proceeding on this as a capital murder?
I'm sorry, Judge, I don't know which one this was.
Roberto Morel.
Oh, okay, Judge, as in capital, I believe it's just murder and robbery.
Well, in count one, you do have it as a murder, a felony murder.
Correct, Judge.
All right, and then count two is an aggravated robbery.
Is Judge.
Okay,
And for the record, I was the court-appointed second chair to Suzanne Kramer before Mr. Aguilera filed his notice. So that's why I was.
okay. All right, so I've granted the motion to have the second chair. And for the record, as she stated, he was previously appointed Miss Suzanne Kramer as first chair and Miss Guerrero as second chair. And that the attorney, Mr. Aguilera, was retained to make the bond.
Yes.
All right. So we can go off the record. So on this case, where are we? Let me see where the other cases are set.
This one was supposed to be set for a bond reduction today. That's why we were out of order.
Okay. All right, Norma, when are the other cases set?
All of them were set for today, Judge.
Okay.
Only 2 are set for today. One was pushed for next week because the council was out of town.
All right, so then what we'll do is let's get a discovery date on this one. And we'll do, because of the nature of the offense, put me at 45 days for discovery.
That's gonna put it at July 24th.
All right, so we're gonna recall it July 24th for discovery. All right, and my understanding, the complainant's family is here.
Yes, Judge.
And so, if you could move this way. To all the parents in the courtroom who are involved in some shape, form, or fashion with regards to these cases, I know that emotions run high. I thank you for not causing any problems coming up, so I appreciate that. So I just want everybody to know that all the people involved are deemed to be adults legally by the court. So I understand that emotions can run high, but I want to remind everyone, we can't do that inside the courtroom and hopefully not outside the courtroom. Just let the legal process, sort itself out. And so to all the persons who come down, who want to see something that is happening in regards to these cases, the first part of the legal process is for me to make sure that the defense has all their discovery so that if someone decides they want to go to trial, they can go to trial. It does no good for people not to have all their discovery and put them to trial, because then that's not fair. So everybody needs to have a level playing field that's fair. So that's what's happening today. So on all of these cases, if there are parents here today related to these cases, it's not going to trial today. It's being reset for discovery. And this case is being reset for discovery for July 24th. All right, thank you, everyone.
Thank you, Judge. May we be excused?
Yes.
And Judge, just so you know, I'm supposed to be on a murder trial on 186 that day, but I think Mr. Aguilera can handle it.
Yes, we're just doing discovery, but thank you.
Thank you, Judge.
You're welcome.
May we be excused?
Yes.
Thank you. I'm gonna want to.
Yeah, interesting cases this morning indeed, Lindsay. That's sad. Any time you see somebody that young involved in something like that, either way, whether he's guilty or not guilty, it's sad. Let's go back to Judge Stevens. He's got somebody in front of him now.
41510 is called the State of Texas versus. I have to read that's you, Mr. Sir. And you're here with Mr. Adams, your attorney, and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that September 3rd, 2020 in Jefferson County, Texas, you committed the second-degree felony of indecency with a child. Do you understand what you were charged with?
Yes, sir.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes. We did, Judge. Yes, sir.
Are you with me?
I'm with you.
I'm good. An agreement's been reached here where you would be pleading guilty and, here, I'm gonna put it in a numerical, and I can't read that you placed in that box. You would be placed in deferred or unadjudicated probation, fined $1,000, up to 10 years on probation. And there would be terms and conditions of probation, which are normal and customary. And there would be registration requirements under the sexual laws of the state of Texas that you must perform. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Guilty.
Sir,
Guilty.
are you pleading guilty voluntarily? That is on your own free will and because you are guilty?
That's some stuff.
Are you pleading guilty on your own free will? Nobody forced you.
Yes.
You're pleading because you are guilty of what this alleges you did in the indictment.
No.
You didn't do this.
You did commit the offense, right?
Yeah. Yes, sir.
What's your final answer?
Yes.
Yes. Okay. Did you just misunderstand?
Yes, sir.
Okay. I mean, you know what you've been charged with.
Yes, sir.
And I'm asking you,
Oh, yes, sir.
is this true, what it alleges?
Yes, sir.
Okay, in the indictment.
Yes, sir.
All right, I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it,
Oh,
discuss
yes,
it
sir.
with your attorney,
Yes,
or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection is submitted. Among other things, this states that you are mentally competent to enter your guilty plea, which is freely and voluntarily made, correct?
Yes, sir.
You understand what you're charged with. You discussed this with your attorney. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you were totally satisfied with the representation provided by your lawyer. All of this is true at state, so help you God.
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objections, it's admitted.
Yeah.
Okay.
No objection.
Pre-sentence report, when?
We need to do a pre-sentence report, Your Honor.
It's a deferred.
Yes, this is a request of probation. They asked that we do a pre-sentence report on sexual assault cases.
For what purpose?
Because of the nature of the offense, Sean, and the complexity of it and.
What's the pre-sentence, what's the difference between, why don't we do a post-sentence report? instead of a pre-sentence report. The quicker he gets on probation, isn't it the better idea?
Well, that's not my opinion, but it's up to you, Your Honor, what you say.
Okay, I think a post-sentence report is important because I want to know what the focus is. But I think that the general terms of probation that are normal and customary for this will be applicable. But if there are specific needs that need to be addressed, we can pick those up in a post-sentence report, okay?
Yes, Your Honor.
Okay, state okay?
Yep.
All right, that's what we'll do when we do. Do you understand the situation here? And you pleaded guilty voluntarily, knowingly, intelligently, and because you are guilty. All right. Anything else to add? I'm going to follow this agreement. You need a pen?
Yeah, I was right. Yeah, look. Hey, I'll take it.
If nothing further, I'm going to find you are pleading guilty today to the second-degree felony of indecency with a child voluntarily. No, intelligent. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm going to defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. Also, we will come back after the post-sentence report is made so that we can review this report, all parties, and if there are any additions or changes that need to be made based upon the findings from the probation office, that will have to be included because we want to prevent or deter any further misconduct. Anything?
I just wanted to make sure that we're putting him on probation today, but doing what would amount to a pre-sentence report.
Yeah, we'll call it a post-sentence because he's been sentenced today. But it would work just like a pre-sentence report if there's something that we need.
Okay. Understood. That's what's the agree on.
What's going on? This is like the most important thing in your life, and you're looking around. What's going on?
People.
Sir?
I was just looking at my people.
This is the most important event in your life, sir.
Yes, sir.
I mean, you're looking at up to 20 years in prison.
Yes, sir.
You want to do some more public affairs, work, or you got to focus on the game here. This is the most important thing in your life, isn't it? 20 years in prison?
Yes, sir.
Okay. And also the victimization of a child. These are all serious things. You're not in a parade waving to the crowd. Yeah. Get your eye involved here. Come on. All right. Anything else, Dan?
That's it.
How long have you been in jail now?
In January 30th.
Of this year?
Yes, sir.
It's about 6 months? 5 months?
Yes, sir.
How's that working out for you? Yeah, I wouldn't be happy with it. You're not enjoying yourself.
No, sir.
Can you imagine what 20 years in prison would be like? Are you focused now?
Yes, sir.
All right. Just have a seat over there and you'll see the probation office and we'll go over terms and conditions of probation.
Thank you all. You can just, that's there.
Just check it out and check it out. Since the probation office and stuff.
Okay, for those of you who may have joined us a little later, at the beginning of the show, I made a statement that at the end of today's show, I'm going to be announcing something very cool. So that'll be in roughly an hour or so stay tuned for that. As I said before, if you like watching court, and I assume you do because you're here, I think you're going to enjoy what I've got for you, so hang tight on that. Let's go back to Judge West, and we'll... I keep hitting wrong buttons today. I got to work on that. Let's go back to Judge West, and we'll continue the parade of fashion.
Figure out, ask them what you need to do, but nobody has had as many issues as you with this drug patch. Do you understand? Have a seat in the jury box. We'll get you tested. And then on Jeremy Niedenthal, that's Mr. Kimmler's. He's not present, but said he would be ready for trial.
Judge, at a time appropriate with the court, I'd like to put a few things on the record.
You can do that now. Yes, sure, of course. And is Jeremy Needham did we tell him to be here? Okay, all right. That's fine.
Judge, the court will recall the hearing we had in the MTRP on the revocation. He was on probation for a Class A misdemeanor. His mom, Miss Taylor,
Yes.
came and testified. I had a very lengthy conversation with her last week. She does not want to come and testify in front of a jury. I think it's my understanding that things have settled down. Mr. Needenthal has been out of custody since he served that sentence on the revocation. They have had no issues. She is begging me and the court to allow a dismissal at this time based on everything that we've put her through and just based on my own sensibility of putting her through that again, where she is at this stage of the game. I would respectfully ask the court to allow me to dismiss.
All right, I'll sign it. Sounds like you've done your due diligence in speaking with her. Thank you, Ms. Malvino.
Okay, well, Texas definitely seems to be where it's at this morning, though apparently the parade is currently at an intermission. So we'll check back, because I have a feeling there's going to be more interesting fashion choices out of her court today. But in the meantime, we'll go back to Judge Stevens, who has another contestant lined up.
Then the arraignment here, can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about March 14th, 2023 in Jefferson County, Texas, you committed the second-degree felony of burglary of a habitation. Do you understand what you were charged with here, sir?
Yes, sir.
If convicted, you okay? Yeah. Hey, I had an allergy attack this weekend myself. I don't know what that was, but I woke up fine today, but
Urgent care, I'm not.
and Ellie's in there kind of sneezing.
Must be the Sahara dust.
The Sahara dust is here already.
Alright.
Is that what rode in on a camel last week? Yeah. Sahara dust.
Hey. You could
What I heard. Into this. You're facing, this is a second-degree felony, which means you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached where you would be pleading guilty, sentenced to 6 years in prison. You would be given credit for all time served, and then another pending case, 23 CR1. Stand by.
0121, Judge.
Somewhere.
0121.
No. I don't know what problem. It's on him.
Is it underneath?
Is it underneath?
Good work.
Yeah.
23 CR 0121 would be dismissed. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of the case. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, that is on your own free will and because you are dishonest?
Yes, sir.
I'm not going to be probation officer, and I'm going to see the terms of statutes that they publish. I'm not sure.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it, discuss it with your attorney, or the contents altered or incorrect?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
And without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states so help you God.
Yes, sir.
State's Exhibit 1.
No objection.
Is made a part of the record without objection. It is admitted. Pre-sentence report is waived.
Yes, sir.
I'm going to follow this agreement and find you are pleading guilty today, sir, voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea. The State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, and I now so find you guilty beyond a reasonable doubt of this burglary of a habitation, second degree felony. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. Do you understand what has happened today?
Yes, sir.
23 CR 121, there's a motion to dismiss this case because of this plea in 111. Any objection?
No objection.
It is done. Thank you. That is all.
Let's head back over to Judge Boyd's court.
Yeah, I had one up in 399, and he pled guilty. So I asked the service to try to reset it for me, and they were able to. Subsequently, but I was trying. Did I give the court the proper notice?
No, you did. I was just wondering how things went.
Oh, he pled.
Okay. All right. So on Adriana Ramos, before we get to bond conditions, where are we on discovery?
I've gotten some, but I don't think I got it all because it looked kind of slow.
Yes, we're actually missing the final document. I need a request from upstairs, so I can confirm that what exactly he's missing, so I can try and get it to him. Additionally, I think he's got the bond stuff that we need to call the victim on as well too.
All right. So y'all are not ready to approach. They need to call the complainant with regards to the bond.
And if I could clean up my motions incorrect. The no contact order is with respect to the man she allegedly cut. The two kids are with him. I told her, don't do anything to go get those kids because she can't have contact with him. I guess what I think is for the best is a court to order how that will be done because she can't have contact with the father.
Okay.
Does that make sense?
Oh, yeah, it makes sense to the court, but you need to confer with the state.
Okay.
All right. Thank
Very
you.
well.
Thank you. Who's here on Clinton Dixon? Good morning. Hello. All right, his plea deadline date is not till June 23rd. I said his plea deadline date is not until June 23rd.
Thank you, Your Honor.
All right, that's what I have on the docket sheet. So you are here requesting a bond reduction?
Yes, Your Honor. He has 3 cases.
Mhm.
The aggravated robbery allegation is $50,000 currently. And on the unauthorized use of the vehicle and the controlled substance case, they're both remand without bond. We're respectfully requesting you set bonds on those 2 cases.
So it's the unauthorized use of a vehicle in the possession case, there's no bond?
That's correct, Your Honor. Do you need the cost numbers?
Oh, no, I have your motions.
Thank you, Your Honor.
All right, have you all been able to confer on a bond amount or no?
We have, Judge. Um,
Is there agreed bond amount or no?
Thousand, PG one was 3,000. I don't know if that's an agreement, that's the statement recommendation.
All right, so unauthorized use, I'm sorry, you're requesting how much?
1,000,
And on the possession less than a gram?
3,000.
So are you in agreement with that, count?
We are, Judge.
All right, we're gonna go on the record. Court is calling 2025 CR 001601 and 2024 CR 009596 State versus Clinton, Dwayne Dixon. Can I have parties announce?
Andrew Harris, Haven.
Robert Featherston representing Mr. Dixon.
And are you Mr. Dixon?
Yes, ma'am.
Okay. All right, we are here on two cases where counsel, you're requesting bond, and then on the 2024 CR 012476, are you requesting a bond reduction on that or no?
We are, Your Honor, and that's not agreed to.
All right. So let's start with what's not agreed to.
All right, Your Honor.
All right, in 2024 CR 012476, counsel, would you like to present evidence for your motion?
Your Honor, I would proffer to the court that Mr. Dixon is indigent. He is also homeless, has no funds whatsoever to post a bond. And currently a $50,000 bond in his circumstances is an instrument of oppression as outlined in our Texas Constitution under current law, which may change in September. But under current law, it's an instrument of oppression. And we respectfully request a reduction of his bond in light of that fact.
And what is the current bond? $50,000.
$50,000, Your Honor.
All right, state.
Whether Mr. Dixon is indigent or not remains to be established since he has not actually provided any evidence. I take Mr. Featherston's statements as true on their face, but they do not in and of themselves constitute evidence. For the court to make a decision on this issue, the court should have some evidence on which to make its choice.
All right, he's saying he was making a proffer. Do you object to his proffer?
No, no.
All right. So there's no objection to your proffer. So you're saying your client is indigent?
That's correct, Your Honor. Also, I'm court appointed to Mr. Dixon because of his indigent status as established by the court.
All right. Then with regards to a bond amount, is there any evidence, any other evidence you wish the court to consider, state?
Okay.
All right, Mr. Dixon, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Lenny Dixon.
All right, and if you were released on bond, do you have a place to stay? Where would you be staying? Where would you be living?
I'd go like to my grandma's house or something.
Well, here's the thing. You say go back to your grandmother's house or something. Have you asked your grandmother if you can stay with her?
I have a key to a house.
No, that's not my question.
Yes, ma'am.
I have the keys to plenty of relatives' house. That doesn't mean that I could stay there. I mean, I'm sure they'd have no problem, but no, my question is, did you ask her whether or not you could stay with her?
I could stay there anytime.
No, my question is, did you ask her? That's
No,
either
ma'am.
yes or no.
No, ma'am.
All right. So if for some reason you're not allowed to live with your grandmother, do you have any other place to live?
No, ma'am.
All right. Now, at your grandmother's house, who all lives there
Just my-
other than your grandmother?
That's my grandmother.
And have you ever in the past been diagnosed with any mental health issues?
Yes, ma'am.
And what would that be?
Schizophrenic, bipolar, ADHD.
All right. And in the past, have you ever used any type of controlled substances, any type of drugs?
Yes, ma'am.
And what would that be?
Marijuana, ecstasy, crystal meth.
All right. Any other questions?
No, Your Honor, the mental health issue is very active.
All right. And the court will note for the record and take judicial notice of the fact that Mr. Featherston is court appointed. And in order to receive court appointments or for a defendant to be appointed counsel, they have to meet financial requirements. And how long have you been in custody, Mr. Dixon?
9 months.
9 months. Do you have any bank accounts with any type of savings? All right. Do you have any funds whatsoever?
No, ma'am.
Do you have any money on your commissary account?
Not money.
All right. All right. So defense, what are you asking for bond?
Your Honor, we respectfully request a bond of about $10,000.
All right. So I can tell you the $10,000 is not going to happen, but state, what are you requesting?
1,000.
All right. The court will grant your bond reduction. The court will set it at $35,000. There's going to be a GPS partial for medical appointments. Waive DPS fees. There's going to be a referral to Center for Healthcare Services. Regular UAs, waive fees. And intensive outpatient treatment. For substance abuse. Waive fees. All right, Ms. Ferguson, if you can make sure he has his reset form for his upcoming
23.
discovery.
Yes.
All right, is there anything else?
No, Your Honor.
All right, thank you.
Thank you, Your Honor.
You're welcome.
Let's continue to stay in Texas, but we'll go back to Judge West.
Action hopefully for us to now be able to discuss a possible resolution before we put it on trial.
All right, so just 30 days, do you think you'll be able to get that? Okay, I'll do one more 30-day reset. Y'all can figure out where you are and we'll get an announcement at the next court date.
Thank you, Your Honor.
Thank you.
Thank you.
You're free to go. See, is there Mr. Turner?
Yep.
Good morning, Mr. Turner. On Deere and Carter, 25 DCCR 0178.
Him to come up as well.
Yes,
There. How are you this morning?
Good, how are you, sir?
Good.
Morning. Good morning, sir. Are you Deere and Carter?
Good morning, Carter. Yes, I am.
And Mr. Carter's charged with assault of a public servant, and what is the announcement?
Judge, I believe we have a plea agreement in place here. It's going to involve a little bit of jail time and reduction, so we're going to ask for a reset to get everything ready.
Okay,
If we could reset for about 30 days, he would plan to come in and do it at that time.
Sure.
And go into custody at that time.
all right, we'll just do a normal 30-day reset then. Make sure you stay in touch with your attorney. He'll let you know when you need to be back, and we'll take care of it.
Who do I need to talk to?
They'll email you the, or send you through the, however,
Hope so.
electronic.
We just leave.
You're just free to go.
Thank you, ma'am.
Thank you. And is Mr. Vallis, Robert Vallis? Mr. Hoffpower, have you talked to Mr. Vallis, the attorney
I have.
on Crystal
I
okay,
recall, I've got nothing. So you know, nothing.
okay. We'll see if they, is Crystal Calvillo? Is your attorney gonna be here this morning?
I don't know why you're not actually. I've communicated with him all morning.
Okay, we'll just hold it for a little bit. Don't leave until we let you know something. And if you can get in touch with them, if you'll just let the bailiff know if you happen to get in touch with them so she can let me know, okay? Thank you. Let's see, Mason Crooks. Come up, Mason. Is the probation officer here on, this is a judicial review.
Yes.
All right, have a seat till he comes back over and then I'll call you back up. I knew it's when I said it out loud, but seriously, there's already emails about the world's best, whatever. Not that me saying that out loud. Mr. Doyle on Maverick Neal.
I'm sorry, but I borrowed time, but I can't tie it.
It's all right, you're good. All right, are you Maverick Neal? And Mr. Neal's charged with aggravated assault with a deadly weapon in 24 DCCR 2436, and what is the announcement?
Judge, we'd reset for me to try to contact the complainant. I'm not getting any answers for written correspondence or the different phone numbers my investigators know to locate for. But I'm not inclined to dismiss because of the seriousness of these charges, Judge. I've made a probation offer, which I believe is going to be rejected. And if that's the case, I guess we're set for trial, and I'll can double our efforts to locate her.
And you intend to go forward with or without?
I believe I can prove the case without her presence, Your Honor.
Okay, so if sounds like there needs to be a rejection done, if there's not going to be, if he does not want to accept any plea agreement, let's get the rejection done this morning. That's on the tablet, and then I'll call you back up when I'm ready to take care of that.
Anthony Whitmire.
See, Mr. Gilthorpe, you have Ramiro Reyes on the sentencing. Sentencing Ramiro Reyes. Morning. Thank you. Good morning. Are you Ramiro Reyes? And Mr. Reyes was previously in court, entered a plea of guilty to the state jail felony offense of theft of property. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes.
Any additions or corrections?
No, no.
Are you sure? Did you read it?
Yeah.
Did you read his version?
Not exactly. Yes. That's the version he gave to the police as well.
So if he didn't do it, then if it's, I purchased an item and then later that person canceled the payment and caused me to catch a charge of theft. I don't understand.
Well, I guess we could add some additions to his version. He was purchasing via Facebook through a third party, which is the information that he cooperated and gave to Solomon Police Department. I believe they're still investigating that.
He was acting on behalf of the person who had multiple people buying. It was a scam.
Yeah. Okay.
It was correct. It was a scam running through Facebook. He was a party in that.
Okay.
And we reached out to Beaumont Police Department based on a Facebook post.
Okay.
He voluntarily went to the police department
all right.
before operating with them.
All right,
And
perfect.
the return of the item was, that's also why state agreed to give him a probation in light of his criminal history.
All right, perfect. Thank you both for that explanation. All right, Mr. Reyes, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I am going to follow the agreement that you made with the district attorney and defer all proceedings for a period of 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. If you do that, then this is an excellent opportunity because you do not have a felony or this felony conviction on your record. And at the end of that probation period, if you're successful, the case gets dismissed. You'll never have this conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to the state jail prison for up to 2 years. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation's gonna call you up when she's ready to go over your paperwork. Good luck to you, sir. Thank you. See, is there a Miss Hawkins here? Julian Hawkins? Okay. See, Mr. Gilmore. Mr. Rojas, you have Arthur Johnson, 24 DCCR 1325. Morning. Good morning, sir. You're Arthur Johnson? And Mr. Johnson is charged with unlawful possession of a firearm by a felon, and what is the announcement?
Your Honor, the state's agreed to all conditions that the defendant forfeits his right to the weapon. The state's agreed to dismiss. The circumstances of this particular case is that his was taken from his home and was stolen, and he went, got it back, and was walking back to his house with it. So as long as he forfeits the weapon, we're agreed not to charge him with it.
So obviously, Mr. Johnson, do you understand you can't have a weapon at all?
Yes, ma'am.
Okay, I'm going to sign that dismissal. Thank you, Mr. Hoffpower, Mr. Rojas. Mr. Johnson, you're free to go.
Thank you.
And the forfeiture.
And I'm signing that forfeiture as well.
Thank you.
Oh, here it is.
Mr. Williams.
And then on Crystal Simeon, Mr. Rojas?
You've got a dismissal on Friday in that case.
Okay.
I received the notification.
Okay, I'll sign that as well.
Excuse you?
Yes, sir, thank you. Okay, thank you. Okay, thank you. Is Christopher Bradson here? I mean, Jason Bradson? Jason Bradson, if you'll call the name, if he's here, he can go.
Jason,
Mr. Bradson, I've signed a dismissal in your case. You're free to go. Yes, sir. And then which was the other one? Let's see, I'm signing. Mr. Kimler's, he's not going to be here, right? Okay. And then Crystal Simeon, that's the one that was Rojas's?
Yes, it was dismissed.
I'm signing that one. I'm just trying to remember which one. Let's see. Luke, which one did you just send over for dismissal?
Crystal sent me, I sent them on Friday. Yes.
Okay, got that. And then Jeremy Needle took care of that one. I just want to make sure none of these people are sitting here waiting. Arthur Johnson. Is there an Arthur Johnson? Did already take care of that
That's
one?
what y'all just took care of.
Yes, ma'am.
All right. Says Mr. Rennick. Did I see Tom? He is Burbank. Mr. Burbank, on Jason Bradson,
My understanding is.
I just signed a dismissal in that case. Yes, thank you. That's the one I was looking for. Yeah, everybody's like, I'll be Jason. Ma'am, I don't think you could pass for Jason, but you never know. Let's see, James Ward, Mr. Burbank.
I'm doing some paperwork.
I'll hold that for that paperwork. And then what about Jermaine Young?
I have to do some paperwork on that too.
I'll hold that as well.
Thank you.
You can see Mr. Crenshaw. Mr. Gilmore, are you ready or do you need a minute? Sure. And then Joanne Hawkins, got some drug tests going on. Marvin, have we seen Marvin? Phyllis? Oh, hold on, let me take care of my, Mason, hold on, now, Mason Crooks? Give me just a second to, pull up. All right, good morning, sir. How are you? Good, and you're Mason Crooks? And Mr. Crooks, you're on probation for theft of property, a third-degree felony. And I received an administrative hearing. Give me just a second to remind myself. So you've been charged with, it looks like another offense of assault, family violence, maybe? Is that correct? But it looks like they're not pursuing that. Is that still the position? And then not reporting online or by mail to Jefferson County for several months.
I have a set of posts. I know that's my fault. Try to understand it.
So
My wife got a vehicle over the week, so I'll be able to start doing more community service.
are you working? Why aren't you working?
The state of Texas took my driver's license away because I take seizure medicine.
So do you not live anywhere where you could get to a job?
Job applications out for the tire shop by our house to where I can work now between 7 and 2 before my wife goes to work for CNN. We haven't had a vehicle about a month, so that's been a problem. But it has, and you can ask Mr. Bro, it has been a problem.
You owe so much money. I mean,
He was afraid I wasn't gonna be able to get it caught up either.
I know, I mean,
The man told me the other man's gonna buy our property when it gets finally cleared, and then the bulldozers there.
I think the thing of it is, Judge, is that, Mr. Crooks, he's been on probation for 2.5 years now, being courtesy supervised over in Orange County, and he seems to be coming up with every excuse in the book. And Orange County is just at the point where they just tired of dealing with it, and they're almost ready to return his case back to Jefferson County. Based off of the offense, that is his uncle.
right.
And so we submitted an order of amended conditions, so, you know, just.
The no contact, I got that. Have there been any other issues since the no contact, since that was signed?
So, not since the no contact was signed. Had an issue with walking by the uncle's house, and the uncle called into the probation department over in Orange County, you know, reporting him saying that, you know, he's taunting or whatnot. And I advised Mr. Crooks to take another route instead of just going by there.
How far apart do y'all live?
I live in Mauriceville, he lives in Orange.
So why would you have been walking by his house?
I had to walk through the neighborhood to get to my direction of home.
From Orange to Mauriceville?
Yes, ma'am. All the houses
where instead of 62 16th Street, I went to all the neighborhoods.
I bet there's a number,
Yeah, there's
any
all-
number of other ways that you can go if you're walking from Orange to Mauriceville instead of in front of your uncle's house who we're having all these issues with.
Yes, ma'am.
That's,
Um,
do you
I
understand?
made a mistake.
Well, but you keep making mistakes, and your mistake's gonna cost you potentially 2 to 10 years in prison. Because this is gonna be the last time we're in court talking about this, all right? One more call about you walking by a house, showing up somewhere where they are, sending a message, whatever it is, however it is, then you're gonna be back in here, and I'm gonna ask your probation officer to file an MTRP. If you're not paying the money and we're not getting the victim of this paid back, then you might as well be sitting in prison. So it's time for you to get busy. You've been on probation for 2.5 years, and from this point forward, it is not gonna go like it has been. There's not gonna be an excuse for everything. Figure it out. Walk, get a bicycle, get a job, and start making payments. I don't care where you're working. Get a job. Figure it out. Make a budget. I want that done quickly. I want you to have a job quickly, and I want you to start making payments. Because what happens is, if you don't start doing everything you're supposed to, Orange is gonna send your case back to Jefferson County. If they do that, 2 options. 1, a motion to revoke your probation because you can't do what you're supposed to over there. 2, you're gonna have to come over here and report and do everything in Jefferson County. So if transportation and all of that's an issue, with just getting around locally, it's gonna be a big issue if you have to come back here.
I understand. Thank you.
All right, this is it. You're on 0 tolerance at this point. Get it all taken care of, or you're gonna be right back in here.
Yes, ma'am.
All right, thank you. Thank you, sir.
Thank you, Mr. Brooks. Have a good day.
You're free to go.
Let's change it up a little bit because it's been a while since we've been there. Let's go to the 27th District in Michigan, and we'll say good morning to Judge.
To my right, Your Honor, this is the date time set for Raymond pretrial. Sir, please state your name. Sir.
All right, thank you. And good morning. Today's date scheduled for the Raymond pretrial in this matter in counsel.
As to arraignment, Your Honor, I advise my client of the nature of the charges, he understands them, all possible penalties. Thereby, we waive formal reading, stand mute as per a pretrial, which we are going to have today as well. We're resolving that.
The court will waive the formal reading and plea of not guilty for purpose of the arraignment and then ask the pretrial counsel.
Your Honor, as to pretrial, after my client being advised of the offer made, he will plead guilty to the amended charge of operating while visibly impaired by alcohol. He understands what that means, Your Honor, and if the court accepts that amended charge, plea of guilty to the operating while visibly impaired, the original charge will be dismissed. He's also pleading guilty to having no insurance on the vehicle at that time. With that, Your Honor, we leave it the court's questioning.
All right, please raise your right hand. Do you solemnly swear or affirm the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes.
All right, you heard the plea that was placed on the record, correct, sir?
Yes.
And as to the amended charge of operating while visibly impaired by alcohol, how do you plead?
Counsel.
And you understand, you've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights?
Yes.
You also understand that by entering into a plea, you'll be waiving some of those rights?
Yes.
And you understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency?
Yes.
Knowing all that, you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
Counsel, if you can please ready your client.
Mr. Otero, on September 15, 2024, approximately 4:17 a.m., were you operating a motor vehicle in the city of Riverview? Yes. Around that time, prior to that time, you were involved in a one-car accident, correct? Yes. In fact, you rolled your vehicle, correct? Yes. And you sustained some injuries, is that correct? Yes. You were subsequently, strike that, beforehand, had you consumed alcoholic beverages? Yes. Before operating that vehicle? Yes. Tell the court what you were drinking, how much? 4 beers, like 6 shots. And you believe that those are all alcoholic in nature, is that correct?
Yes,
And then there came a time where the police responded to the scene, correct?
yes,
You were taken to the hospital because you had hurt yourself pretty bad. In fact, you said you had some fractures in your back, is that correct?
yes,
And at the hospital, you submitted to a blood test, is that correct?
yes,
You agree and stipulate that the blood test was in fact over the legal limit, in fact, it was about 0.20, is that correct?
yes,
And subsequent to that, you stayed in the hospital how many days?
4,
Do you believe that the consumption of your alcohol led to causing that accident?
yes,
I'm satisfied, Your Honor.
All right, counsel, you said 0.20,
That's right.
0.240.
I'm sorry, Your Honor. Yes, I couldn't read my own
All right.
handwriting. Sorry.
The court is satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge. I'm sorry, counsel, also is no insurance. I didn't hear that.
Yes, he's pleading guilty to no insurance. Were your vehicle insured at that time, sir?
no,
You got insurance now, though, right?
yes,
All right. Thank you. Satisfied.
All right, the court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge and to no insurance. And you will receive your, a few things from probation. You want to receive your dates from probation for your pre-sentence interview and your sentencing day. You're also going to receive a copy of your bond conditions, which I'm going to set in just a moment. Your needs assessment link, as well as your pre-sentence interview information. Counsel Esteban.
Your Honor, my client tells me he's not on probation or parole, has nothing pending. This is the first type of this offense for him. Your Honor, there's no reason to believe that he's not going to come back. He's working now full-time at he's working now with the Detroit Free Press, but shortly that place is going to close, and he has a job now pending with BASF, full-time job. He is single, but he does share custody with his daughter, age 4, with the daughter's mother. And Your Honor, one thing that my client has done without any court ordering him, he's seeing a physician, and his physician has prescribed, I forget, what was the name of the drug, sir?
naltrexone.
Basically what it is, it's something that helps with alcohol cravings, like sort of used to be Antabuse, but this is, I guess, the updated version of it. So he's taking steps, Your Honor. He deeply regrets it. He's lucky to be here, quite frankly. So with that, Your Honor, we submit to the court's bond conditions.
Sir, if you're gonna test right now, what's in your system?
Nothing.
Well, you said you were taking some pretty heavy meds at one time for this because
Yes.
when you were in the hospital, right?
Yes,
All right. And
so that was months ago.
yeah.
Okay, well, would naltrexone be in your system?
Yes,
Okay, so nothing wouldn't be accurate.
Okay, no, he's taking prescribed meds.
yeah,
When's the last time you consumed the alcohol, sir?
3 days ago.
You consumed alcohol 3 days ago?
So
You
yes or no?
prescribed naltrexone?
Yes,
How long have you been prescribed naltrexone?
4 months.
So you must have stopped taking your naltrexone.
No, I still take it.
But
Make
you
you
consumed
sick?
alcohol while you're taking the naltrexone?
Yeah, it doesn't make me sick or anything. It just helps with over cravings, like just the urge to keep going.
Okay. Sir, quite frankly, you're lucky to be alive. And so the fact that you're still consuming alcohol while this matter was pending, and you're on a medication to help you not drink, and that you're still drinking is serious, serious cause for concern. Especially for the safety of the public and yourself. So what the court's going to do is the court's going to order a $7,500 personal bond. You are to have an alcohol tether, sir. So I'm going to ask you this question. Do you have, well, you're going to go to EMS tether by tomorrow, and you're going to get that tether, alcohol tether fixed.
Will they add information in the probation department, Your Honor?
Yes.
All right.
You're not to possess or consume any alcohol or drugs that are not prescribed, and you are to make sure you have the alcohol tether on tomorrow. Sir, they will test you. If you have any alcohol in your system, that's cause for incarceration. So I suggest you don't go. and think you're gonna have one last
Yeah.
hurrah. Because not only is that a violation of this court's bond order, it will also land you in custody.
Yes, ma'am.
Okay, we'll see that for sentencing. Thank you.
Thank you, Your Honor.
Okay.
Turn right, then another right, okay?
All right, let's go on the record in the matter of the City of Wyandotte versus Austin, I'm sorry, Riverview versus Austin in 25 R 361651.
Good morning, Your Honor. Attorney Amberly, P 84377, appearing on behalf of Mr. Ignon. I waive his presence for today's hearing.
Okay, good morning. He was here on another matter, I believe, wasn't he?
He does have a separate
Couple
state
weeks?
case.
Okay.
Yes,
And this is the result, this was with that one?
correct, Your Honor.
Okay. And so, Mr. Carlin is dismissing this matter, correct?
Yes, Your Honor. We have no objection to that.
Okay. All right. Yeah, let's have a good day.
Thank you, Your Honor.
Thank you. Okay, let me.
Let's go back to Texas and Judge Stevens. Reminder again, announcement for you at the end of the show here. So coming up in a short while, you'll like it.
These pleading to 2 or 1?
Pleading to 2 to attempted, and there's a cap.
Are they the same type of plea?
Yes, sir.
Agreement?
Yes, sir.
Okay.
No.
She struggled, Judge.
Yeah.
Thank you.
Can't soar with the eagles if you're hooting with the owls all night.
Having that along with the house.
Let me ask you about this.
Yes, sir.
Okay, I'm looking at the indictments which allege first-degree felonies of sexual assault of a child. We're going to develop on attempted.
Yes, sir.
Isn't that 1 degree less?
Yes,
But these are third degrees. From a first degree to a third is not 1 degree less.
the agreement was to drop the first degree enhancement. There's an enhancement in the indictment.
What
Is it a
is
first? It alleges
The child being under the age of, I think, what is it?
no,
younger than 17?
It's the familiar relationship.
Oh, is it? Let me say, Judge.
It alleges a familiar relationship.
I don't think.
It doesn't. Does not.
I think it's just.
Yes, but he was just like, oh, it's intensive. That makes sense.
Can I see the indictment, please, sir?
The
I don't
one?
have my file. Can I see your indictment? Yes, sir. There's an enhancement down here under this last paragraph here. It says have a familiar relationship or prohibited from having sex with because of that relationship. So we're abandoning that and just proceeding on the second degree and then dropping it down to a first degree.
What's that?
This that prohibited from having sex under 25, World 2, I believe, or something along those lines.
Oh.
That makes it a first degree.
Oh.
So we're just
Okay,
abandoning
it
that,
doesn't-
we're abandoning that language,
It
making
didn't
it,
state it just referred to the statute.
yes, sir. Then we're just making it a second degree and then reducing, doing an attempted. So I'm abandoning the language of the familiar part.
Oh, okay. Yeah. Well, there's no language that says that, but it just refers to the general
Yes, sir.
section of 2502.
Yes, sir.
With and this is 429. What are we going to do with 430?
Same thing, same exactly.
Okay, in each of these cases, does the defendant waive formal readings of the indictments and the arraignments here, can we proceed in summary?
He doesn't, we may, Your Honor.
In summary, in cause numbers 23 CR 429 and 430, in summary, these indictments allege that on or about June 1st, 2020, in cause number 429, and on or about August 31st, 2020, in cause number 430, in Jefferson County, Texas, it is alleged you committed the first-degree felonies of sexual assault of a child. Do you understand what you're charged with in each of these cases? Agreements have been reached in each of these cases. You would be pleading guilty to the lesser included offense of attempted
sexual assault of a child, yes, sir.
sexual assault of a child. In each case, which would be third degree felonies in the way the case is indicted under section 2502, that would be dropped.
That is abandoned, yes, Your Honor.
Abandoned by the parties, so the lesser included offense becomes a third degree felony of attempted sexual assault of a child under these circumstances, which means in each of these cases, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreement has been reached. Whatever sentence shall not exceed, is that 3?
Yes, my handwriting.
Yeah, that's sort of. Whatever sentence shall not exceed a cap of 3 years in prison. So what we have here are the options, which would run concurrently with each other. So you're looking at no less than 2 nor more than 3 years confinement in prison.
That's correct.
Deferred or unadjudicated probation could be assessed. Is regular probation
I don't think
an
so.
option under these circumstances?
I don't know, since it's an attempted, it might be.
It's involving a child less than 17.
10 cells usually are 3G as well, right?
Not necessarily.
Anyway, there's going to be a plea agreement, a pre-sentence report prepared. We will all come back, review it, make sure that it's true and accurate. Each party gets to sound in, and then the court will make its decision. Is that your understanding of what's going to happen?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
And again, how do you plead here for this lesser included, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
All right, I'm going to show you what's marked as State's Exhibit 1. Did you sign that document? Yep. Voluntarily, understand it, discuss it with your attorney, or the content's true and correct. State's Exhibit 1 is tendered into evidence and without objection is submitted. Among other things, this states you are mentally competent to enter your guilty plea. It's free and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of this crime and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. And you were totally satisfied with the representation provided by your lawyer. All of this is true. The state so help you God. State's Exhibit 1, part of the record for all purposes. All these pre-sentence report will be prepared to come back on
July 15th.
July 15th. Everybody will sound and the court will make its decision. Do you understand? Okay. That is all. Get a reset.
I'm right there for me.
Okay, we'll go back to Judge Boyd, finish our day out there, and then I'll have that announcement for you after she's done.
Judge, come in. Yes. So. Yes, we were here for a contested, but what's going on?
We are going to be withdrawing now and we will agree to alternate amend conditions for state ISF cognitive program, MRT class, and ISP supervision for 12 months.
Oh,
Correct.
all right, so here's the court's questions. And we're not on the record. Mr. Carney, what is your underlying issues? Or can somebody tell me?
Honor, be honest with you, I was ashamed to come back in your courtroom because you gave me a chance. And with my family, I stay up at my deceased brother's house, and honestly, my family feuding over the insurance policy money and the house, and I got caught in between in the middle. Now, if
Oh, that always happens. Nobody has a will. I always tell people, get a will. As
Yes, ma'am.
someone who doesn't have one, but that's what I say.
recently we all just moved from New Orleans to here, and it was by coincidence he caught a heart attack in his house, and when you let me back, I thought I was going to a safe place, and I wasn't, and I got caught in the middle. Now I'm not
So
gonna.
what's your plan?
My plan is, honestly, 3 years ago, I was in an accident. I was inside of an Uber coming from, I had 2 jobs. I was inside of Uber and got hit by an 18-wheeler. I was about to pay my probation off. I was gonna pay you guys off and try to go back home because I have 2 properties out there I have to take care of.
And where is home?
Port Hudson, Louisiana, and New Orleans. That's where my dad's side of the family from Baton Rouge. My mom is from New Orleans, but I have property out there. I just want to just stop giving y'all state trouble and just do the right thing.
But I understand what you're saying and I'm hearing the words, but I still haven't heard what's your plan.
Our plan is after I win my lawsuit, because I called the guy. I was inside of an Uber. And it's over $1 million.
Okay, let's do this. Let's assume,
I was gonna pay the whole 7,300.
no. Let's do this. Let's pretend. Now, I'm hopeful that you will win your lawsuit. But if you don't win your lawsuit, what is your plan? I'm trying to figure out what's your plan here today, because today you don't have money from a lawsuit. So what is your plan? Because if you don't have a plan, you're going to end up back here on a motion to revoke, looking at life in prison. So what's your plan?
My plan is to get back out there, find a job or two. It's just for my sanity, just work and stay out.
Well, where are you going to be staying? Do you have a place to live?
Yes, ma'am.
And is that at the same place where all of this was happening?
No, ma'am, not at the moment, because the house is up for auction. There's no one really paying the bills.
Oh, that's what ends up happening when you have no will. Everybody thinks they're going to come in a lot of money when somebody passes. And then all of the relatives who never spent time with the person before they pass, and I call them out of town, the out of towners. The out of towners always come in and everybody wants a piece of the property. And then everybody stays at the house and nobody wants to pay taxes on it. Nobody wants to pay utilities. They're just living there. And then the next thing you know, wealth has just left the family because people can't be responsible.
You ain't lying, mister.
So my question again is, let me do it this way. Do you have a place to stay if you're released today?
Yes, ma'am.
And who would you be staying with?
My sister, Felicia Kearney.
And has she said you can stay with her?
Yes, ma'am.
All right. And what are we going to do about employment?
My last month in March and April, I found employment with a family-owned seafood truck with my brother-in-law. His name is Leon Rowe, and his number is.
Oh, I don't need his number. I just need to know. I'm trying to make sure that you have plans, because people are always happy to be continued on probation and then they have no plans and then we come back here. So I'm giving you a choice today, right? Here are your 2 choices. One, the state is saying they want me to sign this motion of withdrawal. I will sign it. Or if you want to just do your time, I will revoke you and I will sentence you to 5 years. All right, so you want the motion to withdrawn?
Yes, ma'am.
All right, Miss Abrams, on this case, he's gonna give you the address of where he'll be living, and that's where you're gonna be living.
Yes, ma'am.
All right, you're gonna give it to probation. Probation, is there anything else he needs?
But I would recommend if we're not doing, the patient treatment, I would recommend the intensive supervision for at least 12 months and the MRT class.
All right, do you believe he needs, any type of treatment?
He's already completed, dual diagnosis residential facility judge.
All right, so we have mental health going on here as well.
He was on the mental health caseload. He finished that. He finished an outpatient program. So, I mean, he finished his anger management. I would say the MRT, and let's keep him on the mental health caseload and the ISP supervision at the very least.
All right, so what I'll do is then the MRT, a referral to Center for Healthcare Services, because I don't want him, if he's supposed to be on medications, I don't want him not on his medications when he leaves the jail. The mid caseload and ISP. Is there anything else you need from the court to be successful?
No, ma'am.
And do you want your case to see if your case can be transferred back to Louisiana?
Yes, ma'am, that'd be nice.
All right, what parishes? Well, you have to pick a parish. You can't say, well, I have property in New Orleans and then I have property in Baton Rouge.
If you give me some time to figure out who I can call down there,
Okay.
and that would be nice, Judge. I appreciate it.
All right, so what we'll do is, because they can't transfer you unless you have a place to stay, he's gonna give you information about what parish in Louisiana. Once that's done, I'll sign the motion for transfer.
Okay, one of them for sure is Zachary, Louisiana.
I'm sorry?
Zachary,
All right, in which part of Louisiana?
that's like a city behind Baton Rouge.
Okay. All right, so just make sure that probation knows specifically which parish you want to transfer to. And you do not want to set yourself up for failure by just naming a parish. So let them know.
Yes,
All right. All righty.
thank you, Ms. Boyd.
Thank you, Judge.
You're welcome.
Okie dokie, friends. So let's talk for a second. We've been for weeks now in the chat and in the members pre-show and everything else. We've been talking about what a loss it has been to not have Judge Fleischer anymore. For those of you who haven't figured it out, he doesn't stream anymore. And there are reasons that we suspect as to why. I actually did a video on that. If you haven't checked that out, go find it. But it's a loss. Not only is he the most entertaining judge, arguably, I mean, some people may differ, but I always felt his courtroom was the most educational. I have yet to find another judge who will regularly go and grab a law book and start thumbing through it when they don't know an answer to something. He didn't ever fake anything. He tried to figure it out. Some of the best legal arguments that we would find would happen in his courtroom. Some of the most thoughtful rulings would happen in his court. And for the record, I did not always agree with Judge Fleischer, but I always respected the fact that he tried very hard, and I assume he still does. We just don't get to see it anymore. So it's a loss, as you're already starting to reflect in the chat. But I really want us to be able to experience that again, but I can't make the guy stream. So what do I do? Well, here's what I do. Now, this is risky what I'm about to do, because if you've seen Ghostbusters, you know from Egon that crossing the streams is bad. So hopefully I don't destroy the world doing this. But right there on your screen is another stream that is now happening here on the Courtroom Files. I have about 160 hours worth of Judge Fleischer footage, and I've so far have prepped 40 hours of it. I've got 120 more to go through. But as of this morning, we are doing a 24/7 Judge Fleischer stream on this channel with the archived footage that I have. When it's all prepped and ready, you would be able to watch for about a week without seeing the same thing twice. And as I'm going through it, prepping it, I'm seeing things that I don't remember seeing before. So you'll definitely experience some new things when you watch this, but it will always be available. Or run 24/7 until somebody tells me I can't, and I don't see why anybody would tell me that I can't. But we're going to run it, and it's going to be there for you guys to experience. Now, this is raw footage from him with two exceptions. I edited out anytime he walks away from the bench, because he tends to leave for an hour at a time. And I also, I've taken out any time where he pauses the stream, so you don't get a stream ended thing that shows on the screen. Other than that, it is exactly as it happened. So I don't edit out periods where he doesn't have somebody in front of him or anything like that. It's just as he streamed it. And that will be available for all of you to enjoy. Now, right now, I am putting a link to it in the chat, but as well, if you just hang around, as soon as this stream ends, YouTube will send you over there. Is it on your channel or another name? No, it is on the Courtroom Files. At some point, as our growth continues, it wouldn't surprise me if we do a spin-off, like a Courtroom Files Archives channel, but for now it will live on the main channel, because I want people to be able to find it, and this channel has the clout as far as the algorithm goes. Once we get to about 50,000 subs, I think we'll probably spin off some of this. I'll probably continue to do this sort of thing with other judges as well, depending on how this goes, but this is where we start. I'm committed to providing good footage. I'm committing to providing good education, and Judge Fleischer fits those bills, and I don't want to not have him. So this is the best I can do for you, and hopefully you all enjoy it. Do me a favor, though. Head over there. This is a live show that happens, so there's an active chat. Put your thoughts in the chat. Put a thumbs up on it, because we need to show the algorithm that this thing exists, because I literally just started it 2 hours ago. I did a test over the weekend that was unlisted, but it's live now for everybody to see. So help people find that. So that's the deal. Aside from that, we'll be back again tomorrow, as always, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members. I will say this: if you want to help support what we're trying to do here, the best way that you can do it beyond just showing up every day is to become a channel member. And there's a link to that in the pinned chat right now. It's $2.99 a month, but every dollar of that goes right back into supporting what we do here, to making improvements. It's that money that actually allowed me to make the changes necessary infrastructure-wise to be able to do multiple streams, so to be able to bring you this 24/7 of Fleischer. So if you want to continue to support that expansion, that's the best way to do it. And the biggest thing that channel members get is access to the pre-show, which I think is one of the better things that we do, because it's just fun. It's a good community. We just chat. I let my hair down, at least the 6 that I have left, and we really enjoy it. So anyways, like I said, we'll see you again tomorrow, 10 a.m. Eastern, 7 a.m. Pacific. Put a thumbs up on the way out if you haven't already. Do consider becoming a channel member. We'll see you tomorrow. Take care. God bless.